From the News Channel 5 Network, this is MorningLine.
Good morning, everyone. Thanks for joining us on MorningLine. Nick Beres here on a Monday. It's just nice to be back in studio after the frigid temperatures of last week, settling back into things, getting back into the news, and taking your phone calls. Not so much the weather, which is news, but today, news. And we're going to talk about some high-profile criminal cases right now, many of which you have very closely followed, with someone intimately involved with all of them, and we'll take your phone calls. And why wouldn't you want to call in this morning and talk with attorney Fletcher Long? Good morning to you, sir.
Morning, Nick.
Nice to have you on. And there's a lot, sometimes with you, Fletcher, I just like to talk about the law. But you are so intimately involved in many of these high-profile cases. Of course, many of you watched our gavel-to-gavel coverage of the Vanderbilt rape trial. There are steps. We're still awaiting for sentencing. I'm going to get that with you. We can talk about the very latest, where we stand on the Bobo case. And you actually are representing, how do you call, or what do you refer to Chris Smith as at this point? And what we're talking about is the shooting at this parking garage over at Vanderbilt a couple of weeks ago. Someone shot and killed. Police looking to interview Chris Smith, who they believe is the other individual on this video showing the shooting occur. What is Chris Smith? Is he a suspect?
I would call him a person of interest, maybe a suspect, sure.
Okay.
But, I think it is the government's onus to prove what he is or isn't. And it's something to which we don't intend to cooperate or contribute.
Now, police, a couple of weeks ago, Metro Police sent out some snippets of that surveillance video and actually put out, a request, or saying that at this point, through you, Chris Smith has, refused to meet with them and talk to them about what happened. Now, he has not been charged. Why will you not allow him to talk with the police?
Well, I don't think it's ever really a good idea to not exercise your Fifth Amendment right of silence. You have a right to remain silent. You have a right to insist that the government prove your guilt beyond a reasonable doubt. I haven't seen the video. That video may very clearly show that the decedent fired first, and that Mr. Smith was merely defending himself. I don't know what the video shows. I think it would be irresponsible for us to go in without any foreknowledge as to what the government has or intends to prove and give some sort of a statement. The law doesn't require it. In fact, the law permits the insistence that you remain silent until you have an opportunity to confront and view what the government has by the way of discovery. And so I've talked about it with my client and my client's family, and that is the position at which we are presently comfortable. So
he's not charged right now?
No, he's not.
Do you believe he will be charged?
Well, I don't know. I mean, that's not my decision. I can think of several alleged offenses that they could presently charge that are not in the vein of a murder or a homicide. I don't know what they will charge, but we're in a holding pattern. We're going to wait and see what is charged, if anything's charged, and then make a decision at that point in time what our response will be.
What, if anything, has Mr. Smith told you about what happened?
Well, obviously, I'm not going to go into what he has relayed to me. But I have a theory that has been given to me, or a statement as to what he believed transpired. I'm going to wait and see what the video shows, because I need to, at this point in time, leave all of his options on the table for a defense.
So the bottom line on this, he's retained you. If he's never charged, then everyone just goes on their merry way. But right now, you're in place should he be charged, and it sounds like you anticipate at some point he may be charged with something.
Well, you can hire an attorney before you're charged.
Sure, of course.
There's nothing wrong with that. Sometimes it's in the investigative stage that you may need an attorney even worse than you need one post-investigation. This is the point in time when the government's going to put together a case, investigate a case, decide whether or not they're going to present a case. And at this point in juncture, a lawyer's advice can be very beneficial.
And you told me before that you're not going to depend on Metro's investigation. You're going to do your own.
Oh, absolutely. We're doing our own investigation, trying to determine we're meeting with potential people that may have seen something, if we can identify who those people are. Obviously, if we can get a copy of, if the government would like to show me what they have on video, we would be very interested to view it. It's generally the government's position we don't have to give you discovery until such time as there is an indictment pending. But you know, we're doing our own investigation. It started with Mr. Smith and his version, but we will not rely on what the people employed by the government turn over as part of their investigation. We will do our own, which is our normal course of business.
Okay, and as you've said, until he's charged, you're not going to cooperate with police.
I'm not going to cooperate with police until such time as I've had an opportunity to view what they have viewed.
Gotcha.
And if they want to show me that, if they'd like to show me what they have viewed, then I may be in a position to make a better recommendation to my client than I am presently. But right now, sitting in the dark, it would be entirely irresponsible for me to take him in there and have him just give some sort of a blind version without knowing what it is that the government believes that he has done.
Gotcha. Okay, okay. And we'll get more to that. We'll follow that story as it goes. I know many of our viewers now are probably most interested in where things stand on two of the other very high-profile cases, and we'll kind of go with the most recent that we've covered, of course, was the Vanderbilt rape trial. It is concluded. We are awaiting sentencing. Fletcher, I know that there was sentencing supposed to have been this month. It's been postponed. Was that because of a scheduling conflict, I think we reported along those lines, right?
I believe that there was a scheduling conflict. I believe it was probably Mr. Robinson's conflict. I don't recall exactly.
Okay.
Obviously, we will continue to prepare the case for sentencing, but one of the things about which we're most interested in preparing is the motion to vacate the jury's verdict based on what we believe to be someone who lied his way to get on the jury in order to ensure that it returned a verdict that fit his preconceived agenda.
Yeah, about how this juror that you're looking into, whether or not he didn't tell the full truth or that he did. And the question's going to come down to what he was asked and how are you going to get hold of the, I guess, the notes that were taken by the court reporter. Are you guys taking that to take a look and see what was asked and what was answered?
Well, every person on the defense team, regardless of which defendant they defended, has a clear recollection of him having been asked a question or multiple questions which should have elicited the information, not even just by us, but by the government lawyers too. So, I mean, he had plenty of opportunity to give us an appropriate response based on the question that he was asked that he didn't that he didn't.
Okay, and this was he was a statutory rape victim.
You remember he took an oath when he was impaneled as a veneerman. He took an oath that he would answer our questions truthfully and completely in order for us to determine whether or not he had biases that would make him someone who shouldn't serve on a jury with this particular subject matter, and he clearly was that someone who shouldn't have served on a jury with this particular subject matter.
I think, as we've heard, his attorney said after the fact, when the story broke, that he didn't consider himself a victim. Perhaps.
Well, I think that's a bunch of hokey.
Okay.
I think that is disingenuous at best to a rank falsehood at worst.
If it were found that there is a juror, and we can talk in general terms here, who was not truthful in answering the questions, gets on the jury, and then perhaps in some ways influences the verdict, and that's proven, is that grounds for a new trial? Is that what that would be?
It is grounds for a new trial, and the case law seems to suggest that someone who is asked a sufficient query to elicit the information who does not answer that query with the information, the presumption is that he is biased. Now here you have a foreman who didn't answer the question, got on the jury, according to our investigation, volunteered to be the foreman, almost insisted that he be the foreman, then announces a verdict, jumps on television, talks about the great joy that the announcing of that verdict brought him and how he wanted, it was on your station, wanted to look them in the eye, you know, and so I would say that all of those things are the sine qua non of bias and the sine qua non of agenda. And I believe that this is going to be quite an event.
Is this something that you're
eliciting
file?
This from him?
Okay,
yeah.
Sentencing still is next month, I believe. So, are you going to wait to file something till after this? Is this something that comes up on appeal, or is this something you can move on as soon as you get maybe these notes from the court reporters showing the questions, so you have that as a backup?
Well, it's my anticipation that as soon as we get the notes from the court reporter and are able to cite to the actual record as to what was or wasn't inquired into it at the voir dire stage, that there would be motions coming at that level. Now, I want everybody to understand that obviously we're into the post-trial appellate mode, and of course Brandon has the option of not continuing on with Long and Herbison should he choose. You know, he may wish to go another route.
Your client, Brandon Vandenberg.
Right.
Yes.
And in the appellate realm, and if he wants to go another route, he should. Mm-hmm. And that lawyer should come into place now pretty quickly because they would want to be involved in the argument and in the preparation of the brief and memoranda for new trial.
If we can, and I know that's something you'll be focused on now, this appeal, or, you know, whoever handles it for him. Sentencing, just question. Based on what he was found guilty of, I've had a lot of questions from people. Is this something where he would have to face things consecutively or concurrently, you know, because there were a lot of guilty verdicts back. It could add up to hundreds and hundreds of years. A lot of people, and Nick Leonardo, who you know, our legal analyst, said, listen, I think this starts at around 15 years, and it'll be somewhere between maybe 15 and 25 is what the judge could come back with. What do you think?
That's the range of punishment. I don't see any basis for consecutive sentencing under the sentencing guidelines. That doesn't mean that one won't be imposed, but there isn't a legal basis for it. But we've done a lot of things in this trial that are almost novel in criminal jurisprudence. But
sure.
You know, just reading the sentencing guideline structures, I don't see any basis for consecutive sentencing. I would anticipate that he would probably get a 20-year at 100% sentence. Okay. And that all of these sentences would run concurrent. Obviously, some of the convictions will have a lower sentencing range than the A felonies, but I think that he'll get a multitude of sentences, but I don't anticipate any of them running consecutive.
Okay. And I know you didn't represent Corey Beatty, but he was found guilty of the same, so you could assume
I think he'll get the same sentence, right.
All right, listen,
he actually was charged with less.
Yeah, that's right. That's right.
Yeah.
He was. So we're going to take a break on that, and we just covered two of those cases. When we come back as well, we can talk more about that, take some of your questions there. We'll open up the phone lines, or if you'd like to talk about the very latest on the Holly Bobo case. And I just want to hit you on that because, frankly, that case just keeps dragging. And I know you're frustrated with it. I know the judge is frustrated. Where is it going? Because that's the next big case out there. The number is 737-7587. If you want to jump in, questions or comments for Fletcher Long, we'll get to those and more right after this.